Deputy Speaker.
Member for Morani.
I rise to speak on the Criminal Code, Serious Vilification and Hate Crimes and Other Legislation Amendment Bill 2023. According to the Premier, the changes made by this bill will give the strongest set of hate speech and hate crime laws in the country. One of the bill's stated goals is to make it easier to prosecute people for serious vilification or hate speech in Queensland. In order to achieve this, the bill amends the state's Anti-Discrimination Act, removing the necessity for Attorney-General's consent prior to the commencement of a prosecution, and relocates Section 131A of the Act to Part 2 of the Criminal Code. This inclusion of hate speech offences in the Criminal Code opens the door for politically motivated and vexatious complaints to be made against certain individuals and groups, particularly those who don't go along with the political establishment's woke agenda. The bill increases the maximum prison sentence for public acts of hate speech from 6 months to 3 years. Public acts are defined as any form of communication to the public, included by speaking, writing, printing, displaying notices or by electronic means, which means people's social media posts will also be policed. Part 4 of the bill empowers police officers— I'm not taking interjections, Deputy Speaker— stop, detain and search a person or vehicle without a warrant and seize evidence of the commission of offence created by this bill. There are also provisions reversing the onus of proof, which means defendants will be presumed guilty until proven innocent in the court of law. This bill gives no clear definition for hate speech or hate crime, neither does it provide any test for how such offences are to be identified or measured. In her introductory speech to Parliamentary, the Attorney-General said the new laws will protect members of our LGBTI+ community from hate crimes and hate speech. Elsewhere in the speech, she cited the example of someone being misgendered in hospital as an example of possible hate crime captured under the bill. If misgendering someone is to be regarded as an offence under the bill, then clearly the parameters for hate speech are to be drawn very widely indeed. Something as simple as stating a belief that a man cannot breastfeed could put you on the wrong side of this bill. In other changes, the bill will allow the Attorney-General to ban a symbol or image without having to go through Parliament. That's the beauty of these so-called framework or umbrella bills for governments. Loosely drafted, they give no more than a broad policy outline that then can be filled later at a later date via regulation. It makes umbrella legislation the perfect vehicle for mission creep, Deputy Speaker, leaving governments with plenty of scope for more expanded criminalisation of speech over time. The bill therefore creates a new head of power for banning symbols and images, but provides no detail to which symbols and images will be prohibited under the new laws. In fact, the only symbols mentioned in the connection with this proposed bill have been the Nazi swastika and the ISIS flag. This is a common trick by governments when seeking to introduce oppressive powers, and the formula is to create an association in public mind between the proposed legislation and an already reviled outgroup for whom most people already feel extreme distaste. And this ensures that no one will feel compelled to speak out against the new powers in case they are accused of defending the reviled group and their abhorrent ideology. Of course, once this bill passes, those new powers can be expanded much more widely until every group of the government set out to target has been captured. Giving an Attorney-General the power to designate a hate symbol is therefore extraordinarily dangerous, and it violates what is regarded as a fundamental democratic principle that the key concepts creating criminal liability should not be made by regulation. It also creates a situation where the government may choose to pursue an ideological agenda and a means with which to target a particular group that disagrees with the government's policy agenda as a hate group and to ban its logo or its flag as hate symbols, all without any recourse to a normal parliamentary process, Mr Deputy Speaker. Section 52D of the bill also creates a new offence relating to the public display and public distribution or publication prohibited symbol in a way that might reasonably be expected to cause a member of the public to feel menaced, harassed or offended. By criminalising behaviour that might be expected to cause someone to feel menaced, harassed or offended, the bill embeds a highly subjective element at the core of Queensland hate crimes legislation. In doing so, it sets a very low bar for criminality, especially given the highly subjective nature of words like expected, harassed, offended and menaced. According to the bill's explanatory notes, this new offence is intended to capture a broad range of circumstances, including the public display of tattoos and the public distribution or publication of prohibited symbols online. And the bill purports to provide a number of free speech safeguards by allowing exemptions for those who can prove their conduct consists of reasonable and genuine contribution to literacy, artistic, political, scientific, religious or academic discourse. Those seeking to exercise their rights under this clause, however, should be warned that the burden of proof will be on them proving that their offence is not an offence under the Act and that their defence is reasonable and genuine. If they fail to do so, they face 6 months in prison. And how many artists, journalists, collectors or academics do you think will be prepared to take such a risk? Not many. And finally, the bill adds a circumstance of aggravation to offences under the Criminal Code, including offences such as trespass, public nuisance, wilful damage, harassment, abuse, intimidation, unlawful stalking, threats and common assault. Under subsection 52B, the circumstances of aggravation is applicable where a person was wholly or partially motivated to commit the offence by hatred or serious contempt for a person or group of persons. In the past, criminal provisions applied to the offence of serious vilification included the element of actual incitement of hatred for a person or group. And under this bill, however, an offence can be branded a hate crime and a person's prison sentence substantially increased on the basis of subjective interpretation alone. In fact, the whole notion of criminal offences being aggravated by hateful feelings and motives will take Queensland further into the territory of thought crimes. People will be punished more severely, not for what they have done, but for what they have allegedly thinking or feeling at the time. How can any justice system consistently or fairly identify signs of contempt or hatred for a prescribed group as the motivating catalyst behind a criminal act? Who or what defines hate, and who can say what another person was thinking or feeling when they committed a crime or an offence? It also makes the reversal of the onus of proof doubly reprehensible, given such accusations will be almost impossible to defend in court. It will end in hate crime status being judged purely on the basis of the prescribed group, status of the offender and victim, leading to a two-tier justice system and the obliteration of equality before the law. Deputy Speaker, I believe this is a dangerous bill. Not only will it have incredibly chilling effect on people's speech, but their thoughts as well. The bill supposedly allows for reasonable and genuine contributions in the context of literary, artistic, religious, educational, historical, legal, law enforcement purposes or for a public interest purpose. But who decides this? How will the terms like reasonable and genuine be defined or measured? All are inherently subjective. Also, as the Queensland Council of Civil Liberties said in its submission on the bill, the fact that someone might be offended is not an appropriate ground for restricting speech, as too many things offend people. The bill's religious protections are also very uncertain. Ostensibly, religion is included as a protected characteristic, but is extremely unlikely that anything in this bill will protect a Christian where their beliefs may come into conflict with the new gender ideology. Anyone who thinks otherwise should concede that the case in Finland, where the politician is being prosecuted for tweeting out a Bible verse in response to her church's sponsorship of a pride event. Free speech is far too important, Deputy Speaker, for us to stand by and watch it being cancelled in this way, which is why I'll be asking the opposition to review this bill if they get back into power in the next elections. The free citizenry should be able to criticise their government's policies without fear of persecution and imprisonment. It seems to me that the real goal of the bill, such as this one, is to strong-arm the people into conformity with a state of authorised narrative and ideology that cannot, in any real sense, be challenged. It is not only possible, but extremely likely that such laws will be radically abused in the future. And as for being vilified, as a South Sea Islander, I know exactly what that's like, but we still need to have free speech. Some people say that Kanaka is a bad word. We actually wear that as a badge of honour. So we understand it, but it's very difficult to really capture what's really here in this bill and when it's all arranged and how this is actually going to pan out. Thank you, Deputy Speaker.
Deputy Speaker. Member for